Good morning, everybody. We really appreciate you joining us today. Brown & Brown is excited to do a second round of the introduction of the Paid Leave Act that has been introduced here in Connecticut. As many of you know, everybody should be registered. If you're not, make sure you get registered. First payments were due March 31st for that first quarter. And obviously you have a 30-day opportunity to make that up by April 30th, but please make sure that you're registered. That's most important. And today we have with us Erin, and Erin is with us from the Paid Leave Authority. A little bit about Erin. Prior to joining the Paid Leave Authority, she worked at the Department of Administrative Services for 14 years, directing the agency's legislative and general legal functions. She's a trusted advisor to 7 commissioners of the Department of Administrative Services. She has over 20 years experience in handling discrimination claims before the Connecticut Commission on Human Rights and Opportunities. And if any of you have ever had the opportunity to face that, you know that that is a very difficult task. So she is up for this task. She co-authored the Family and Medical Leave Entitlements Manual and extensive and detailed guide to understanding and administering federal and state family and medical leave laws, which may be new to many of you who've joined today's call. Many of you may be employers with less than 50 employees and may have never had to encounter the family medical leave. So Erin will be able to provide us with a little bit of background on that. She is also a frequent presenter of management training and sexual harassment prevention workshops. She's recognized as an expert in employment-related issues in the state of Connecticut governmental agencies. She attended college at the College of Holy Cross, and she is a Columbia Law School graduate. So we thank you, Erin, for joining us today and being our guest speaker and for laying all of this out. I just appreciate the time that you've taken to provide this guidance to our clients, our prospects, all those who are in attendance today. And at the end, folks, we'll be able to answer any questions. Amber and Erin are going to monitor that throughout the presentation today and hopefully be able to answer this. This is being recorded, and we can provide a copy of the recording and the slides after we finish this up today. So with that, we'll let Erin run loose today and give us an introduction on what we can expect in 2022.
Thank you so much, Kathy. I really appreciate that introduction and the invitation to join you all today. I'm going to go ahead and share my screen so we can jump into the slide deck, which we will be sharing after the presentation. You can just confirm, Amber or Kathy, that you see my screen.
We can see your screen, Erin.
Great. So, going to jump straight into the content. So, we are focusing on employers who have fewer than 50 employees today. So I'm not really going to talk too much about the federal FMLA. We're going to talk about the Connecticut FMLA, the Paid Family Medical Leave Act, otherwise known as the Connecticut Paid Leave Act. And then we'll really get into information that is more pertinent to the employers here today, sort of what your responsibilities are, what the processes are, and how they differ for job protected leave versus income replacement. And then I have a couple of examples to try and put it all together. If we have time, I'll give you a little bit of information about private plans and additional resources, but I really want to make sure we have time to address questions and answers. So if you have questions during the presentation, please put them into the Q&A. I can't see if you're raising your hand, so that's not a useful way of communicating. Just type your questions in and Amber will curate that as we go. So the Connecticut Paid Leave Authority. We're a quasi-public agency that was created by Public Act 19-25 with the purpose of providing a mechanism for employees to be able to take the time they need to care for themselves or their loved ones without worrying about the lost income that really can be devastating to families if they are unable to receive any income while they're out for medical reasons. So that mission is to provide the benefits to the employees who are out, but we also see our role as helping employers, administrators, healthcare providers, really everyone who's involved in the process to understand what their roles are, make sure they understand what they need to do. By statute, we are charged with engaging in outreach and education, so we really do appreciate opportunities like today to fulfill that part of our mission. Um, the Paid Leave Authority is a brand new quasi, so we also have to stand ourselves up and develop our policies and procedures. As a quasi, we don't have regulations. We have publicly noticed policies and procedures that have to be approved by our board. We also, by statute, have the responsibility of receiving the employee contributions and establishing the contribution rate. By statute, the contribution rate cannot exceed 0.5%, but in the future, if our trust fund reserves become healthy enough, we may be able to reduce that contribution rate. As I mentioned, there is an opportunity for employers to say, we want to offer our employees an equivalent or better plan. And if they want to do that, they can apply to the authority for approval. And then we will be auditing those private plans. And then starting in January of 2022, which is right around the corner, we will be administering claims for paid leave benefits. We are in the process of negotiating with a third-party administrator for that side of our work. Just a few key dates to keep in mind as you're thinking about 2021 and how quickly it's going. As Kathy mentioned, we really do need all employers to register. Our registration opened in November of 2020, and we've got significant proportion of employers in Connecticut have registered. But if you haven't yet, please do so. I'll tell you later how to do so. The obligation to start deducting the contributions began on January 1, 2021. And then those contributions are remitted to the authority on a quarterly basis. We do give you a 1-month grace period at the end of each quarter. We want to be consistent with Department of Labor and Revenue Services. So get your contributions in by the end of the month. And then our goal is to have our claims administration portal up and running so that people can start filing their claims in December. We won't be issuing any benefits until January, but we know that there's a backlog and that people are sort of planning for us to be around. And so we want to be able to start receiving applications before the benefit payments begin in January, which, as I said, is January 1st, 2022, right around the corner. Okay, so if you're an employer with fewer than 50 employees, you've probably never dealt with FMLA before. So let's start with what that means. FMLA is the acronym that stands for Family and Medical Leave Act. There are actually 2 different statutes that are called FMLA. There's one that's applicable to employers with 50 or more employees, and that's the federal FMLA. And then there's also Connecticut's own FMLA. Both of these laws allow eligible employees to take job-protected time away from work for applicable reasons. And under both of these laws, the leave is unpaid. Okay, so the law only provides the job protection. Both laws say that the employer may adopt policies that would allow an employee to receive some sort of income replacement from the employer while they're out on leave. Some employers just continue to pay their employees while they're out. You see this often with parental leave. Many employers say you can use your earned accruals, either their sick leave or their sick leave and vacation leave, or maybe they have a single PTO bucket. And so that's what employees would use if they need to. Some employers also offer short-term or long-term disability, and that's all allowed. The Connecticut FMLA has been on the books since the 90s, but it is going to change significantly as of January 1st, 2022. And I really want to focus on those changes today. Before we talk a little bit more about Connecticut FMLA, I do need to explain what PFML is, or Connecticut Paid Leave. People use those terms interchangeably. Paid Family Medical Leave, CT Paid Leave Act, PFML, depending on who you're talking to. That's the new law that was enacted in Public Act 1925, and it is a separate law from the Connecticut FMLA. Our law is Connecticut General Statute 31-49E. Connecticut FMLA is Connecticut General Statute 31-51KK. If anyone wants to go check that out. Our law creates a source of income replacement benefits that's separate from anything the employer does. And it is benefits that are available to eligible employees who are not receiving income because they're out of work for covered conditions. Our law does not provide for any job protection. This is also the law that created the authority. Okay. Connecticut Paid Leave Act and the changes to the Connecticut FMLA are new, but they're not novel in the sense that they sort of fit into an existing universe of other laws that relate to leave, employee leave from work. As I mentioned, there's the federal FMLA that's also been on the books since the 90s, and that applies to employers with 50 or more employees. As I mentioned, Connecticut FMLA has been around, but up until January of 2022, you probably haven't worried about it because it only applied to employers with 75 or more employees. But starting in January, it's going to apply to employers with 1 or more employees. In addition to these two FMLAs, there's workers' comp, which has been around for over a century, and that provides benefits to employees who are injured for covered on-the-job injuries and illnesses. And it also has certain job protection elements associated with it. There's also the Americans with Disabilities Act and the Pregnancy Disability Act. Both of these federal laws apply to employers with 15 or more employees, and they say that leave may be a reasonable accommodation. It's not an absolute entitlement, but employers have to consider whether it's a reasonable accommodation or whether it would cause an undue burden. And finally, we have the Connecticut Fair Employment Practices Act, which applies to employers with 3 or more employees. The Connecticut Fair Employment Practices Act, or CFEPA, says that you have to consider leave as a reasonable accommodation for employees with disabilities. And it also mandates that employers provide a reasonable amount of leave to individuals during the period of disability caused by pregnancy. And traditionally, that's understood as usually about 6 to 8 weeks. So we have job protected leave that's in the world, and we've had it around, and you should have been thinking about it, particularly with connection to ADA, PDA, and CFEPA. But other than workers' comp, we really haven't had any laws in Connecticut that allow for income replacement, and so that's why Connecticut Paid Leave Act is new. For both Connecticut FMLA and the Connecticut Paid Leave Act, you have to show you want to be out of work for a qualifying reason. It's not anything. It has to be a documented, supported reason. And these are the reasons that are covered. To create or expand your family with a new baby who's been born to you, or you've adopted, or taking a placement with foster care, which we call bonding leave, opportunity to bond with that new family member. There's also caregiver leave, which allows you to take time away from work to care for a family member with a serious health condition. More about that in a minute. Of course, you can take time away from work for your own serious health condition if you need to receive treatment or recover from a serious illness or injury. I just want to point out that serious health condition statutorily includes being an organ or bone marrow donor, as well as being pregnant. So those routine prenatal visits, as well as any more serious complications, are covered under pregnancy. There is special leave to care for a family member who's injured in the military. That's called military caregiver leave. There's also leave called qualifying exigency leave that an employee can take when their parent, spouse, or child has been called to overseas active duty for specific reasons. And then finally, in Connecticut, we have the Connecticut Family Violence Leave Act. This is a law that's been applicable since about 2012, and it allows employees to take job-protected time away from work up to 12 calendar days in a calendar year, unpaid, if they need to relocate, go to court, receive counseling or treatment because they have been directly impacted by family violence. And under the Connecticut Paid Leave Act, employees could come to the authority for income during those 12 unpaid days. So these are the reasons. I did want to take a moment to talk a little bit more about caregiver leave. As I said, caregiver leave is leave that the employee can take to provide care to a family member who is seriously ill. The family member could be your parent, your spouse, your son or daughter of any age. Now that's a change. It used to be restricted in age, but as of 2022, it'll be a son or daughter of any age. It will also be expanded to include the siblings, grandparents, or grandchildren of your employee. In addition, an employee could take caregiver leave to care for an individual who's related to the employee by blood or affinity, whose close association the employee shows is the equivalent of one of those listed family relationships. This relation by affinity is relatively new to Connecticut, but it's actually been around for over 20 years in the federal government. They've used this definition for federal contractor sick leave. They've also used it for their bereavement leave and some of their other policies. And other states and municipalities have used this. Basically, the relation by affinity is intended to recognize that families don't always look like Ozzie and Harriet Nelson, right? Or the Seavers, if you want to bring the television reference up a couple decades. Or I can't even think of modern families, but the Modern Family, maybe. It actually looks a little bit closer to the Modern Family. People have chosen families. People have relationships that are equivalent to a parent, spouse, sibling who may not be the actual person on the family tree. That could be the aunt or an uncle who relies on the employee for unpaid care and who has had such a close relationship that you would normally have seen it with standing in the place of a parent or as the grandparent. Connecticut doesn't recognize common law marriages. So right now, if you are in a relationship with another person that might be considered a common law marriage in another state, you would not be able to take caregiver leave for that person if you weren't married. But as of 2022, that unmarried significant other with whom you maintain a familial spouse-like relationship, despite the lack of a license, that would be covered by related by affinity. There are a number of examples, and each situation is very specific. And we are working with Department of Labor to determine the documentation required to support this. But it is a change that we want you to be aware of. All right. So you have to have a covered reason. You can't just say, I want to take time off. It has to be a covered reason, caregiver, bonding, whatever. You have to be eligible. To take the leave, job protected leave, you have to show that you were employed by your employer for at least 3 months. That's it. There's no hours worked requirement. And this is something that you as the employer will be determining because the employee comes to you for job protected leave. To be eligible for income replacement benefits, the employee has to earn at least $2,325 in their highest earning quarter when we look at the first 4 quarters of the 5 quarters immediately before they make a claim. That first 4 of the 5 is basically because we'll be validating this wage information using DOL data, and DOL data comes in a quarter behind. An employee can be eligible for income replacement benefits based on their earnings from multiple employers. So if you have employees who work part-time for you and part-time for somebody else, they may never earn the $23.25 from you, but if you add it all together, they're eligible. And that was intentional by the legislature to make sure that those employees would be covered. In addition to earning the $23.25, the employee has to show that they are currently employed in Connecticut or that they had been employed at some point in the 12 weeks before they made the claim. Because eligibility for job protection is different from eligibility for income replacement, it is perfectly possible that an employee may lose their job because they don't have any job protected leave, but they're still out of work for a covered reason. And so again, the legislature wanted to make sure that they were able to get benefits. Finally, the Connecticut Paid Leave Act allows sole proprietors or self-employed individuals to opt in. They're not employees, they're the business owner or they're self-employed. So like workers' comp, they're not obligated to participate, but they have the opportunity to participate if they want to. And if they've opted in, they're making contributions, and they can show that they've earned the 23-25, they could receive benefits. As I mentioned, eligibility for job protected leave is determined by the employer. Eligibility for paid leave benefits is determined by the authority. Third sort of basic question about these benefits: how long do you get them? How long can I be out on job protected leave? How long can I get income replacement? And the answer is 12 weeks in a 12-month period, except there are a couple caveats. For job protected leave, it's 12 weeks in a 12-month period, unless the employee is asking for military caregiver leave. An employee can take a one-time leave entitlement of up to 26 weeks in a 12-month period for military caregiver. As I mentioned, there also are those 12 days in a calendar year for family violence leave. And the statute, as of January of 2022, will also allow employees to receive up to 2 additional weeks of leave for incapacity due to pregnancy. To receive benefits from the authority, it's that same 12 weeks in a 12-month period for all leave reasons, including military caregiver. We only have 12 weeks, not 26. But as I noted, 12 days of those 12 weeks may be used for income replacement during family violence. And we also have that 2 additional weeks of income replacement for incapacity due to pregnancy. Okay, so covered reason, eligible, length of time. We have the basics of both laws. What does this mean to you as the employer? Well, just like there's 2 laws, there's 2 sets of responsibilities. In connection with the Connecticut Paid Leave Act, we need you to register. You will be responsible for calculating your employees' contributions. So the employees actually fund the paid leave trust, but they do so out of their payroll. And since you're responsible for payroll, we need you to calculate the contributions and remit those contributions to us on a quarterly basis. And then next year, once we start claims administration, we will be reaching out to you when employees come asking for income replacement benefits, so we can get confirmation about their absences and any employer-provided PTO. That's in the Connecticut Paid Leave Act. In connection with the Connecticut FMLA, employers have more responsibilities because FMLA is an employer-administered leave program. In this time before January 1st, 2022, you want to work with your advisors and develop your own FMLA policy if you don't have one already. The Connecticut Department of Labor and the U.S. Department of Labor provide some really good resources. You can adapt. The Connecticut Paid Leave Authority is also creating resources like this website, like this webinar, to help employers understand their new obligations. And then you need to notify your employees what your policy will be. And then starting in January, your employees will come to you and ask you for job protected leave. And you will be the one to confirm that the reason for leave is covered, determine that they're eligible, and track their leave usage. All right. Going back to your responsibilities with regard to Connecticut paid leave, we need you to register if you haven't done so already. The first step to registering is actually to create your credentials with business.ct.gov, which is applicable to the entire state of Connecticut. All state agencies over the next few years will be requiring the businesses that interact with them to create their account with business.ct.gov with the goal of having a one-stop portal. So in the future, that will be your place to go whenever you interact with any agency in the state. So register your business, take those credentials, and then come to ctpaidleave.org and click on the button to register. It takes about 10 to 15 minutes, and we just need to know who you are, a little bit about your business, and who you want us to contact. So please do that if you haven't already. The second thing you need to do is calculate the contributions and remit them to, second and third thing, calculate the contributions and remit them to the authority. The contributions, as I said, are 1/2 of 1%. These contributions are post-tax, so they don't reduce your employees' taxable wages. They're based on the employee's wages as you've already calculated them for purposes of FICA. So if the wages, include the regular salary, but it includes certain benefits, but not your pension plan, not your healthcare benefits. So you're already doing that when you're determining what your employees' wages are for purposes of their FICA obligation. You take that FICA number, you take the 0.5% from that, and that becomes their contribution. The obligation to begin taking those contributions started in January. If you didn't do so starting right in January, we do have a short-term sort of catch-up period allowed for you where you can collect up to an additional 1% on top of the 0.5% to do some catch-up payments or withholdings so that you can make sure that the contributions are collected. You have to do this and get caught up by the end of June of 2021. If you make these catch-up payments, you don't need specific written permission from DOL, and you don't need permission from your employees. You can just go ahead and do these catch-up payments to just get yourself caught up. And then from there you go on. The contributions are capped at the Social Security contribution limit, which is currently $142,800. So once the employee hits that number, they don't make any more contributions. And as I said, you remit them on the quarterly basis. Individual employers can remit them right through the account they created when they registered. So they go to ctpayleave.org and click on the button to remit the payments. And there's sort of some basic information that you'll enter and then tell us how you're going to pay us. It's going to be through ACH or whatever. If you have a third-party administrator, the TPA will file the benefits on your third-party administrator, like a payroll provider. They'll be filing the contributions on your behalf. We have videos and fact sheets on our website for the more specific information about how to actually process the information and get them to us. So if you're interested, please check out our website for those specific informations on the contributions. Okay, moving right along so that we have time for questions. Let me just go over the two separate processes, one for job protected leave and the other for income replacement benefits. Employees will apply to their employer for job protected leave. They notify you that they need leave. They should be doing so 30 days in advance if the need for leave is foreseeable, or as soon as practicable if the need is not. You determine if they're eligible. Under Connecticut regulations, you have 2 business days to do that. This is not leave approval. This is just, have you met the 3 months? And you tell the employees if they need to provide you documentation to support the reason for leave. The employee provides the documentation. You have to give them at least 15 calendar days. And if they have trouble, you really need to give them a grace period. It doesn't have to be more than 15 more days. Once you receive their documentation, so the medical certification or the adoption papers or the military information, you review it. And if it's sufficient, you tell the employee you're approved or you're denied. And you tell them what they need to do. If they need to report in, if you need a fitness for duty, and whether to use paid leave accruals. And then the employee has to report to you when they're out so that you can track their leave usage. The employee may not be eligible for job protected leave under Connecticut FMLA. So you have to consider, are they eligible for leave under a different statute, like as a reasonable accommodation under the ADA or PDA or CFIPA? They may not be, but you need to engage in that analysis. You can't just say, no FMLA, you're out of luck. So they could be eligible for Connecticut, they could be eligible for leave under another statute, or they may not be eligible for job protected leave at all. You need to let the employee know. And you also need to let the employee know if they're eligible for any employer provided income replacement. What are your policies about paid time off? Are you going to require your employees to use their sick leave accruals or vacation accruals? You are allowed to do so. And if you're worried about employees taking more time off than the statutory 12 weeks, you really should seriously consider having a policy that requires them to use their accruals. However, one of the changes to Connecticut FMLA is that employer cannot require the employee to exhaust all of their PTO while they're out on FMLA leave. You must allow the employee to hold on to at least 2 weeks so that they can use it for other purposes. As I mentioned, some employers offer short-term or long-term disability policies. You really need to look at the language of those specific policies, but most of them will say the employee has to use employer accruals first, and would have to use any state provided benefits first. They consider themselves the payer of last resort. The employer makes those decisions. The employer does not make decisions about whether an employee is eligible for income replacement under the Connecticut Paid Leave Act. That is the responsibility of the Connecticut Paid Leave Authority. An employee could receive benefits from both the authority and the employer at the same time, as long as the combined amount does not exceed 100% of the employee's regular wages. On the other hand, an employee who's receiving workers' compensation benefits by statute cannot get any benefits from the authority. And as I mentioned, an employee may be able to get benefits from the paid leave authority, even if they're not eligible for job protected leave. So you may have to say, I'm sorry, you're not eligible for job protected leave, and we can't hold your position for you, but they could still come to us for income replacement. One caveat here is that if you have an approved private plan, you are standing in the role of the authority, and so you would be determining if the employee is eligible for benefits under that approved private plan. So, employees coming to you for job protected leave, and you'll tell them about income replacement through your own policies, your accruals, and all that. The employee comes to the Paid Leave Authority for paid leave benefits under Connecticut Paid Leave Act. When they come to us, we or our third-party administrator will be validating that the employee is eligible and that the reason for leave qualifies. We calculate the benefit amount, but before we can really issue those benefit checks, we need to communicate with you and the employee to validate the employee's absences and to calculate any offsets based on employer-provided paid time off. And then we'll issue the benefit payments directly to the employee. The benefit payments are determined by statute. If an employee earns less than or equal to the minimum wage times 40, right now, so it's $12 times 40 is $4.80, the employee will receive 95% of their base weekly earnings. If they earn more than Connecticut minimum wage times 40, their benefit rate will be that minimum wage times 40 plus 60% of the difference between what they earn and $4.80. In all situations, the weekly benefit is capped at 60 times the Connecticut minimum wage. So this is why you can see an employee may want to receive benefits from us and supplement that by benefits from their employer. All right, I'm just going to do a couple of examples to put it all together and then race through some other resources so we can get to the questions. So in my example, Acme Industries has 30 employees working in Connecticut. One of whom is Wiley, who's been working there for 10 years. And he's got 4 weeks of sick leave and a couple weeks of vacation. He gets hurt on January 31st. It's non-work related, and he needs to be out for 8 weeks. So what does Wiley get? What are his opportunities? He does get job protected leave because he's worked for Acme for more than 3 months. And he has income replacement available to him through his earned sick leave and through CTP leave benefits. Now, Acme does want to make sure that their employees don't stack one benefit on top of another, so they require their employees to use their accruals up until the 2 weeks that they have to hold in reserve. So Wiley's CTFMLA job protected leave will begin on February 1st and go through the end of March. He will use his 4 weeks of sick leave accruals to receive income during February, and then he can come to the Paid Leave Authority to receive income replacement benefits for March. When Wiley comes back to work at the end of March, he will have used up 8 of the 12 weeks available to him for job protected leave, but only 4 weeks of the 12 available to him for income replacement from the Connecticut Paid Leave Authority. Okay, so in September, Wiley learns that his mom needs major surgery and he would like to take time off to care for her. He wants 8 weeks off. Now, he's been back for a few months, so he's earned back 5 additional days of sick leave and he hasn't touched his vacation. Does Wiley still get job protected leave? And what kind of income replacement is he entitled to? Well, Wiley's still eligible for federal FMLA because he still worked for the company for more than 3 months, but his leave entitlement is down to 4 weeks because you only get 12 in a year and he's already used up 8. So he's got job protected leave for the first 4 weeks that he wants to be out. The employer can require him to use those 5 days of sick leave, but again, can't be forced to use the 2 weeks of vacation he's got in reserve. So while he's probably coming to the paid leave authority for wage replacement benefits for the remainder of the time. The employer is not required to hold Wiley's job open for the full 8 weeks because he's only got 4 weeks of job protection available to him under the statute. So it's going to be up to the employer to decide, are we going to let him go in November? Are we going to tell him that if he wants to take the time off in November, that's up to him, but you're not holding the job and he'll have to reapply when he comes back? Or maybe you let him do it. That's up to you. If he were out for his own serious health condition, not for his mother, you would have to consider whether leave for the month of November would be a reasonable accommodation if he has a disability. But there is no accommodation for caregiver leave. So it's totally up to you. Whether or not he's got job protection for the full 8 weeks, he does have income replacement benefits available because he hasn't used up his entire allotment from the paid leave authority. Okay. Gone through a lot of information and I do want to get to questions. So I'm just going to give you some resources to check out after we're done here today. Go to ctpaidleave.org. Make us a favorite. We add information all the time. It's a great website. One of the things you can find is our employer toolkit, as well as posters, rack cards, mailers, FAQs that give you information, but also enable you to provide information to your employees so that they understand why they're having contributions taken out and what their benefits are starting next year. There's even a contribution calculator so that you and your employees can figure out how much to, or at least estimate what the contributions will be. All of these resources are available in color and in black and white. You can print them out, you can send them as emails. They're also available in English and Spanish. Additionally, we have videos for employers and employees, both on our website and on YouTube. If you look us up on YouTube, you can find a lot of our old webinars. We have a very lengthy FAQ section that you can look through. And if you still can't find the information you need, you can go to our Contact Us portal. I want to get to questions, so I'm not going to talk too much about the private plans, but there's a whole section on our website explaining the private plan process and the application process. We're still receiving applications for private plans. You had to have received an approved private plan by March 31st to be excused from Q1 contributions. So if you're not one of the 250 companies who got approval for Q1, you do have to remit your Q1 contributions, but you could, if you want to, submit an application for the future to get in before June 30th. You'll be excused and get approved. You'll be excused for Q2. So that's an option for you. It's work. So I just want to tell you, it's not something that you just sort of think it eliminates all your work. It's just different responsibilities, but it's something you may want to consider. And as I said, it's all on our website. So having fast-paced through a lot of information, let's see what kind of questions we're getting in. Amber, is there anything that looks like there have been a few things coming through?
Erin, we do have a few questions in here, so I'll go ahead and start at the top and work my way through. We have a payroll company handling all of our payroll processing, and they have been taking the employee contributions each pay period. I presume they are making the payments to the state. What is our role as the employer in this program?
So yes, your payroll processor will be taking the contributions and they will remit those contributions to the state. As the employer, however, we still want you to register. Your payroll processor, check with them. Most of the payroll processors are saying that they will not handle the employer registration because there's some information like who at the job site you want us to contact that they don't have. So you'll fulfill your contribution obligation by virtue of the work that the payroll processor is doing, but it's still a good idea to go on to ctpaidleave.org, click on the registration button, and make sure that you complete your employer-specific registration so that you can provide information like, who should we be in touch with when your employees come and ask us for income replacement benefits?
Okay, thank you. And can we pay per pay period or just at the end of each quarter?
So, yes. We set it up for quarterly payments because that was what the majority of employers told us they wanted to do, but we are opening it up now for more frequent payments, and so that is something you can do.
Great, thank you, Erin. And where do we submit our deductions? Through MyConnect or another online portal?
So you broke out. I couldn't hear. I apologize for my dog. I couldn't hear what you said about the portal.
They want to know if they can, where to submit their payroll deductions. Would it be through MyConnect or another online portal?
Okay, so MyConnect is the IRS portal, and that is not us. So you would have to come to ctpaidleave.org, and through the account that you create when you register, you'll be able to remit your contributions that way.
Okay, thank you. And this one is in regards to a sole proprietor. If I am the only employee of my LLC and I don't have payroll, I just take member draws, do I need to contribute? Since my draws are ad hoc and vary in size, how would I actually calculate my quarterly contribution?
Yeah, so if you are the sole proprietor or self-employed and you do not pay yourself a W-2, that's really the big distinction. And it sounds like this person doesn't because they're taking draws. You are not required to participate. You can choose to, and you would remit your contributions based on your estimated quarterly self-employment earnings, the way you would calculate your self-employment earnings for tax purposes. But you're not required to. On the other hand, if you set up your business so that you are your own employee and you issue W-2s, then you're an employee and you would remit contributions like any other employee based on your payroll.
Okay, great. And this is also asking, as a sole proprietor, if I don't want to enroll, do I still need to register?
If you are a sole proprietor who does not choose to enroll, you do not need to register.
Okay, great. That concludes our questions for the moment. So I'd just like to ask everybody if you have questions. We do have time scheduled and we do want to answer those for you. So please utilize the QA feature at the bottom of your screen to submit your questions so we can answer them live.
Looks like we got something new in. Oh, here they go. Everyone's typing away.
There we go. In the meantime, I'm going to drop a link in the chat for everyone. The link is to our YouTube page where we have other recorded webinars on a multitude of different topics. So if you want to check those out, I will be putting that link to our YouTube page in the chat in just a moment.
So I see in the chat someone's asking about the deck being available. So the slide deck is not on our website, but we will share it with Kathy and she can distribute it to anyone who's registered. Okay, so the question looks like they came in about the calculation for the contributions. So the calculation, and the question specifically, is it based on gross or net? And I'm not going to answer that question because I'm a lawyer, and why would I answer the question presented? But what I am going to give you is the more specific answer, which is the calculation is based on the wages as you determine the wages for purposes of FICA. Okay, so it's after tax. So you meaning that the contribution does not reduce your employee's federal or state taxable obligation. So that's why it's after tax. But it is based on that FICA number. So it's basically, I think it's box 14 of the W-2. That's the number you use. And you just take that number and you multiply the 0.5% from that to determine what the contribution is.
Okay. And does the deduction apply to new employees currently in a probationary period?
Yep, it applies to all of your employees, whether or not they're permanent or probationary, part-time, per diem. applies to everybody.
Okay. And are there specific step-by-step instructions available for TPAs to submit employers' quarterly contributions?
Yes, there are instructions available for the payroll processors and TPAs who are submitting the contributions. They're doing it generally through a batch process. And so they have information for how to do that. And then we also have instructions for how to remit if you're doing it sort of on a one-off basis through our website. I see the question is coming in saying someone's having trouble getting into their account. So if you go to our website and click on the Contact Us button, that will prompt you to fill out an email that tells us what the problem is. That's the best way to get the fastest and best resolution to your problem. Sometimes we can go in and fix it ourselves. Sometimes we'll email you and tell you what you need to do. Or if you need to, we can set up a phone call to walk you through the solution. I can tell you that one really quick test before you do any of that is just make sure you're using an up-to-date browser. If you're using a non-supported browser, it would have made it difficult for you to register to begin with, but it also makes it difficult to remit the contributions. So Internet Explorer in particular is causing people a lot of problems. So very first thing, kind of equivalent to turning it off in 93 seconds, turning it back on. Very first thing when any sort of internet is to check and try a different browser. But if that doesn't work, go to Contact Us, tell us your problem, and we'll fix it.
All right. And we have being an accountant, when you say after tax, it sounds like it is after taxes subtracted, i.e. FICA and federal. Will I just use the FICA wages box?
Yes, use the FICA wages box and take the 0.5% from that number.
Okay. And what about 1099 employees? Do they withhold, or is the 1099 person's responsibility?
Yeah, so people who receive 1099s are independent contractors, not employees. So this is me, again, being an employment lawyer, being really precise, probably annoyingly so. But if you're getting a 1099, you're not an employee. So you as the employer do not have any obligation to withhold any contributions from those contractors. If that individual contractor has decided to self-enroll, they will have to remit their contributions themselves based on their own earnings. It's not something you have to worry about.
Okay, great. I did have one come through in the chat. So how fast does the quarterly reporting take to post to our CT Leave account if done through a third-party administrator?
I don't actually know the answer to that question. I can tell you that most of the third-party administrators are taking advantage of that 30-day grace period. So many of them have not yet remitted the contributions. So if you have any questions about whether it's been remitted, please contact them and find out when they're planning on remitting. I do know we're getting notices every day, so I think it does get posted pretty quickly, but I don't have an exact 6 hours, 12 hours sort of number to give you.
Okay, and again, everyone, if you have any other questions, please submit them using the QA feature at the bottom of your screen. We would like to get to those questions for you. In the meantime, I have submitted a couple of links to our YouTube page and to our Contact Us portal. So for those of you who have any questions after this webinar has ended, please feel free to utilize that Contact Us portal to get answers to your questions. I just want to remind everyone in the group, this webinar is being recorded and will be posted to our YouTube page within the next couple of days. And Brown will be provided with a copy of the presentation deck that Erin has presented to you today. So all of you will have access to that should you want to use that. You'll also receive a follow-up email from Zoom if you registered through Zoom. And with the follow-up email, you will receive links to the presentation and the recording. Erin, it looks like that concludes our questions. So I'm going to go ahead and throw the ball over to Kathy. Thank you so much.
Thank you all. I really appreciate everybody who joined today. Erin, thank you so much for being clear and concise with all of those answers. I know it's a lot. to be put on the spot and have answers quickly. So thank you for doing that, Amber. Thank you for running this so smoothly. And like Erin and Amber said, we will have copies of all of the information shared today along with links. So if you registered, expect an email follow-up from us just to make sure that you have everything. In the meantime, if you have any questions that you feel weren't answered or you need additional help or guidance, please feel free to reach out to us here at Brown & Brown. We'll be happy to help you however we can. So thanks, everybody. Have a great day and enjoy some of that sunshine.